Hi everyone, I think we're going to get started now. Thanks. Thanks everyone for joining us, both online and in the room. My name's Katrina. I'm on the Stewardship Committee of Legal Voices for the Future. For those of you who haven't been to one of our events before or who haven't heard of us, we are, as it says on the slide, a collaborative learning forum, and we're run by early career practitioners. And what we aim to do is kind of teach junior lawyers and law students about climate and nature issues, and particularly how they intersect with the law. So what we're kind of trying to do is bring about, bottom-up change within the legal industry so that we all are aware of these issues and can speak authoritatively on them. Tonight, we're really, really grateful to be hosted by the Grantham Research Institute, who are our long-standing partner, and they've done loads for us. So thank you very much to the Grantham Institute. Just a bit of housekeeping. So in terms of if there's a fire alarm, there isn't meant to be one, or it means that there is a problem. So you need to go to the fire exits, which are beside the lift. If you need to use the bathroom, they're just kind of down the corridor and to the left. If you need to get water, it's just the kitchen next door. And also, we are going to be taking photographs of the event, but if anyone doesn't want to be photographed, just speak to one of us, so one of the Stewardship Committee members, and we'll make sure that they aren't published online and we don't take any photos of you. And also just a few things that we'll kind of mention at the end as well. But we've got a few really interesting events coming up. So we've got a careers event coming up on the 11th of October. So we're going to have some really, really interesting people from across the kind of legal climate world. So you can sign up for that by the 30th of September. You just have to do a little application form. But Emma's going to give a bit more detail about that at the end. And the other thing just to mention is that me and all of the rest of the committee, we're all volunteers. So this is all done through our kind of extra time. And we do have costs like for running LVF, which are increasing. And at the minute, we kind of fund those by individual donations. So if anyone is interested and is able to donate to us, you can do that through our Buy Me a Coffee page, which is going to be on one of the final slides. Yeah, I suppose turning to tonight's session, so this is our September knowledge session, which is the first one we've had for 2 months because we had a little bit of a break. And this one's really exciting. We're going to be talking about the, the role of NGOs in driving climate laws. And we've got some really, really interesting speakers. So online, we've got David Kay from Opportunity Green. We've got Sophie Marjanac from the Polluters Pay Project, Guillermo Miranda Garcia at the Chancery Lane Project, and Ricky Gamma from Leitane. So how it's going to work is that Dominika, who's hosting the session and who is our deputy co-chair, she is going to give a presentation on the role of NGOs, and then we're going to move to the panel session with the panelists that I just mentioned. Then we'll have a short break for refreshments and things like that, and then we will move on to the creative content section, where we'll be discussing a video that Dominika is going to talk through with you. So yeah, if you have any questions during the session, for those online, we've got a Slido thing where you can submit questions, and then we can put them to the panelists during the panel session. And then for those in the room, save up your questions and you can ask them during the panel. And then finally, afterwards, for those in London, we will be heading to the pub afterwards. So please join us there. For those online, if there's any issues with like tech or you can't see us or hear us, please just write in the chat. We've got people monitoring them. So yeah, I'm going to hand over to Dominika now, who's going to go for her presentation. Thank you. Yes. You want me to just do that?
Sorry, just another technical difficulty before we start.
Lovely. It wasn't so difficult.
Hello, everyone. Thank you for coming. Thank you for joining us today. I know it's a Monday, so I really, really appreciate the in-person attendance in the room, but online attendance as well, goes without saying. My name is Dominika. As Kat just mentioned, I am Deputy Chair of Legal Voices for the Future, but I am also Legal Officer at Opportunity Green, which is, surprise, surprise, a climate change NGO. Yay. So when I first got my job offer at Opportunity Green, a year and a half ago now, loads of people who were lawyers kept asking me what it is that I would be doing at Opportunity Green as a lawyer. I had questions like, so would you be reviewing Opportunity Green's contracts, or would you be kind of defending them if they get sued? And I knew that the answers to those questions were no and no. And I knew that what I would be doing is I would be kind of using legal tools to actually further Opportunity Green's mission, which is to combat climate change. But the practicalities and the day-to-day of exactly what I would be doing, I actually had no idea about. And so this is how the idea for this knowledge session really came about. And here I should actually give a shout out to Marina, who is our fellow stewardship committee member, who actually gave me the idea, because we were having a chat about how good it would be to discuss what it actually entails to be a lawyer who works at or with climate change NGOs. That's why we're all here today. And I've tried to minimize my speaking time so that we can hear more from our amazing panel who just have incredible expertise and experience to share with us, which I'm really excited about. But I will introduce a couple of key concepts on what NGOs are and kind of how they function, although I appreciate it's very basic, so please do bear with me. What is an NGO? It's a non-governmental organization. Yay. NGOs operate independently of the government. They are normally non-profits, and they are motivated by specific values or missions and causes. So essentially, an NGO's purpose would be to address a specific issue within society. So in our case, that would be climate change, likely. Okay. Essentially, each NGO will have a specific strategy of how they achieve what they set out to achieve. And sometimes this is referred to as theory of change. In very basic terms, what a theory of change is it's a roadmap that outlines how a specific project or how the NGO as a whole will achieve its intended goals. And the usual formula is very simple. It's if we do X, then Y will happen, and this will result in Z. So to give an example, it's right there again, very, very, very basic. If we successfully challenge the inadequate emission reductions of Shell, Shell will be forced to adopt more emission reductions, and therefore there will be less greenhouse gas emissions. So that's how theories of change work. So effectively, theory of change as a concept really embodies like the key motivation behind NGOs, which is to come up with effective strategies to deliver on their end goal. To do so, as in deliver on their end goal, NGOs need funding. Funding can come from a variety of different sources. There are philanthropic organizations which provide grants. There is litigation-specific funding. There are donations, either from high net worth individuals or from mere mortals as well. There are membership platforms and structures. There's crowdfunding, and so on and so forth. To justify why particular NGOs' work deserves funding, having a strong and unique theory of change or the equivalent is really helpful. So that's why that concept is particularly important. Funding is usually separated into restricted versus unrestricted within kind of the NGO setup. So restricted funding can normally only be used towards a specific purpose. So for example, it would be to pay the salaries of people who are working on a specific project that is funded by a specific funder. Whereas unrestricted funding is really the unicorn that is just so perfect because you can just spend it on whatever you want, basically. And it's really, really hard to get. And when you do, it's really exciting and nice. So we are not going into the panel discussion just yet. So in fulfilling their mission, again, NGOs will be motivated by their purpose and whatever it is that they were set up to do, but they will also be motivated by accountability to their existing funders, as well as perhaps wanting to attract further funding. It is clear that NGOs play a significant role in the development of climate laws. And again, perhaps the most often used example is strategic litigation, whereby we know many cases which were initiated by NGOs and made quite the waves within the legal space, such as the Klima Signorinen case at the European Court of Human Rights, or the Milieu de Fancy case in the Dutch courts. In today's knowledge session, we will zoom in on the work that goes into making sure that NGOs are these big players within the climate space. And I hope that this session will be useful to a range of people that we see in the room today. You might be in private practice wanting to work with NGOs as clients. You might be working at an NGO and just wondering what people at other NGOs do, which is totally fine. Nothing wrong with being curious. You might be wanting to have a career as an NGO lawyer, which is also super cool, and so on and so forth. So I hope that today's session will be useful to all of you. And to this end, we will be zooming in on how NGOs use the law to achieve their end goals. There are a number of tools that such NGOs can use. So there's, again, litigious versus non-litigious strategies. Strategic litigation is kind of a buzzword, but as hopefully we will see today, there are loads of other ways in which you can use your legal knowledge for the good within an NGO setting. There are national or international laws to use. There are legal actions targeting supply of fossil fuels versus demand of fossil fuels. And I could go on and on. And that's really why for today's session, I'm beyond delighted to be joined by a wonderful, incredible panel of experts who have amazing breadth of expertise when it comes to working at or with NGOs. I have deliberately invited speakers from a wide range of organizations, and this diversity really kind of embodies this variety of tools that I was just referring to. So it is my great pleasure to welcome Sophie Marjanak, who is, I just realized that Kat has actually done the intros already. So could I please ask the speakers to come up front? Yes, I have said thank you a million times, and I will say it one more time. Thank you so much to all of you for joining us today. We're delighted to have you here. And we will start off with the first question, which is the very basics. Please tell us about what your organization does and a recent piece of work that you did that you are particularly proud of or that you found particularly interesting. And before you answer, apologies, one more caveat. We have Ricky here from Leitane, and Leitane is, of course, not an NGO, but Ricky has worked with a range of amazing organizations, and so we'll be able to speak to that vast amount of experience. And if you could please tell us about how climate change work fits into your practice at Leitane and a recent piece of litigation or advice that you did on behalf of a climate change NGO. So to start, shall we start with you, Sophie?
Okay. Go first. Is this on? Yep.
I think it's on.
Okay. Hi everyone. Can you? I don't think it is on. Is that okay?
Yeah.
Okay. My name's Sophie Marjanak. I am the Director of Legal Strategy at a small organisation called the Polluter Pays Project. I'm an Australian qualified solicitor. I qualified in 2011, and I've been with the Polluter Pays Project for 9 months. So we're a small startup in the not-for-profit space. And what we do is to work on a particularly niche topic related to fossil fuels, which is the decommissioning of oil and gas assets. So cleanup of those assets at the end of their productive life, and the implementation and enforcement of the Polluter Pays principle, hence our name. We have, as I say, just constituted ourselves and are growing relatively rapidly, but hoping to remain quite a small organisation, focusing on 5 target jurisdictions where oil and gas basins are mature for industry. So where there's an opportunity to pin the costs of cleanup on industry. And so our target countries are the UK, Australia, Canada, Nigeria, and Brazil to begin with. Noting that, of course, that is a small selection, but when thinking about impact and starting an organisation, you have to start somewhere, and sometimes you have to start small and then grow. So we are being relatively targeted with our work to begin with. Should I go? What? Recent piece of work. So I'll talk about how we use legal tools in the second question, because legal tools are just one of our impact pathways. So we use a number of different strategies to achieve change. Our vision is that the polluter pays principle will be respected, and that oil and gas companies will pay for and internalize the true costs of their fossil fuels and all cleanup, fundamentally, we're doing this because those costs are extremely large. It's about 80% of the capital cost of building a new fossil fuel project, decommission and restore land or marine environment to its previous state. So those costs are very often put off onto others, smaller operators, or assets are sold before they're productive, and then the smaller operator often becomes insolvent, and industry tends to avoid those costs. A recent piece of work. This may seem tangential, but I hope that it will come together if I talk a bit more about what we do. But recently, we've been working in Nigeria, as I mentioned, where Shell and the other major international oil companies have all very recently, in the past few years, divested their assets to local companies, and they have done so without fully funding or ensuring that the purchaser has the capacity to fund the remediation of oil spills and legacy damage that has occurred in Nigeria since the 1950s, and significantly since the 70s. One of the things that we did to try and draw attention to this issue was communicate to the UN Working Group on Business and Human Rights. So the UN Special Procedures, some of you might be familiar with that, where organisations with awareness of human rights abuse can complain to the special rapporteurs or the working group. We did that. We had a successful outcome. We had 6 special rapporteurs, including special rapporteur on human rights, environment, toxics, rural people, poverty, etc., and the UN Working Group. So, 7 UN mandate holders appointed by the Human Rights Council. That's a pretty good result. We were quite pleased. They wrote a really strong letter to the divesting entities and also the host states of those entities. So on paper, our result was fantastic, and this is, I'll go to kind of, when I start to talk about impact, I think this is a really good example, but we struggled to get that reported on in any major international press in the last month, and that's why you probably not heard of it. 2 to 3 years ago, that would have been in the FT, and we would have landed that story, but they didn't want to take the story. So I think, anyway, we can talk a bit more about that, but I think that shows that when you're thinking about impact and the law, there's a real difference between what you can achieve on paper, albeit this is obviously a soft law mechanism, so the enforcement is weak to non-existent, but even in trying to have some impact in the real world from that intervention, the current kind of geopolitical context and the media and erosion of trust in the UN and failure to trust UN institutions or see any follow-up, and Gaza, frankly, stopped us from having much public and media impact with that particular intervention. So that's why I picked that story for today. Thank you.
Hey everyone. If I sit back, can people hear me online? I am a lawyer at a law firm called Leitane. So we're not an NGO, although our clients are sometimes NGOs. Leitane is a claimant-only law firm, so it does all types of claimant work. A lot of that is for individuals or groups of individuals. In terms of environmental work, we have a team of lawyers who do group claims, and particularly international group claims. So they would bring claims on behalf of large groups of individuals who've been affected by the actions of multinationals who have a significant presence in the UK. So Shell is a good example. I work in the public law team, so mostly I bring, or my team brings, judicial review claims, mostly on behalf of NGOs or also community groups, or so smaller campaign groups on the full range of environmental issues. So a lot of that work is climate work. That might be challenging consents for fossil fuel projects, or challenging airport expansion proposals on climate grounds, or challenging government policies on climate grounds. So, for example, challenging the net zero strategy or the government's food strategy, or the jet zero strategy, which was the policy for decarbonising aviation. But then we also do other types of environmental work. So lots of work on water pollution at the moment, both sewage pollution and agricultural pollution, and then work on wildlife issues. So a lot of work on the impacts of the hunting industry on wildlife, and then also work on greenwashing. So that's more soft law remedies, like going to the Advertising Standards Authority to bring complaints about greenwashing in advertising. In terms of a piece of work I'm particularly proud of, I think, Dominika, you said particularly a climate piece of work.
Yes, please.
So we've done a huge number of climate cases. I guess one that's relevant at the moment is we've done a lot of work for campaign groups in Lincolnshire, where there are a number of smaller both gas and unconventional gas or fracking projects. We brought a judicial review last year against a project in Biscathorpe. It was a gas well in Lincolnshire, and we successfully quashed the planning permission for the project in the High Court. That was off the back of another case that you might have heard of, which is the Finch case in the Supreme Courts, which our team also acted on. But I mention that now because Lincolnshire County Council is now controlled by Reform, and Reform are determined to consent as much oil and gas as possible. And so we're working with communities there to look at other projects which are coming down the line. So I mention it because it is it connects to some of the political issues that we're facing at the moment, where a while ago there was general consensus about the need to address the climate crisis, even if there wasn't sufficient action, but that consensus has now disappeared, and that does open up some avenues for legal challenge, and we'll carry on bringing those while we still can.
Amazing. Thank you very much. Guillermo?
Yes, thank you. Hello, everyone. I'm Guillermo Miranda Garcia. I'm a lawyer from Mexico. I'm currently working here in the UK for the Chancery Lane project. The Chancery Lane project is basically working in the non-contentious space of climate change. I think in that perspective, we can do a lot because we try to help organizations and obviously lawyers as well, advising those organizations to embed sustainability into their own day-to-day documents and processes. So basically, we started to do climate contracting, embedding into your day-to-day contracts your targets and the things that you want to achieve, because it's a way that moves quickly and you can actually monitor very well in case you're delivering the impact or not. So we basically started as a hackathon of lawyers working during COVID to help create this content. And it's been growing a lot. I was telling that we're pivoted from strategy because first we were centering in decarbonization, which is a very difficult line to follow from a contract to decarbonization. So now we're trying climate risks. We're also talking to the lawyers to be more climate conscious and do their lawyering, even if you're an M&A lawyer, if you're a real estate, just to have some kind of architecture in your deals to actually deal with this and start talking more with your clients about this. So it's basically from a perspective of making the lawyers change a mindset, which I know we're going to talk of blockers later on, but I think it's a little bit of systems change, a little bit of mentality change, but it also starts with the students, because we also know that there's not mention whatsoever of environmental laws or climate conscious lawyering in the legal education, in the materials you have to study for the SQE. So we're trying actually to change that and to start pushing for more policy on that. So basically our main point is that the contracts are the building blocks for the economy. So if you change the precedent, you can actually change a lot in the trillions of dollars that are governed by those contracts. And in terms of an interesting project that I've been doing lately, it's an e-learning program that we just made in the beginning of this year. It's online already. Everything we do is, we're non-for-profit, and everything we do is free of charge. So this is an e-learning platform for people to go in through 6 modules, from an introduction of what's climate change, what do you have to know as a lawyer, scope 1, 2, 3, all the basics. But then it takes you to a more, I would say, a more user-centered piece where you can learn how to start talking with this, about this with your clients, and also how to use it in your day-to-day, because we also have the content and the documents that you can use in your practice. So that was a very interesting project. We're very close to Legal Voices. Thanks again, Dominika, for the invitation. Because one of our most important things is foster the collaboration and the community building, especially with young lawyers, but also with practitioners in all the stages, because we were born from collaboration, and we think the only way to actually push these documents, this mindset, is through collaboration in law firms, in in-house departments, and in academia. So thank you very much.
Thank you. And it's always a pleasure to work with TCLP. We've done it time and time again, and we'll continue to do so. And last but not least, my boss, David.
Hi everyone. Can I just check everyone can hear me?
Yes.
Yeah. Okay. Excellent. Well, firstly, thank you very much for inviting me along, and I'm very sorry to not be there in person. I actually live up in Scotland, and it was just a bit complicated for me to get down to London today. But thank you for welcoming me online anyway. As Dominika says, I'm the legal director at Opportunity Green. I trained as a solicitor in private practice and worked for several years as a commercial and corporate lawyer before doing an LLM in climate change law and moving to Opportunity Green a few years ago. If for those of you who haven't heard of Opportunity Green, it's quite a young organization, so you may not have done. It's coming up to its 4th anniversary. In that time, it's grown fairly rapidly. And it focuses on demand side sectors where emissions are still going up. So aviation, shipping, steel, agriculture, heavy duty trucks, and we do some finance work as well. And the legal team is only one strand of what the NGO as a whole does. So we tackle climate change from a few different angles that are kind of complementary but distinct. So we have a climate diplomacy team that works with climate vulnerable countries to increase climate ambition at the international level. We've got an advocacy team that works with first movers in industry, building coalitions to advance climate policy. And we also have an analytics team that kind of underpins all of that and supports across all our work streams with scientific and economic arguments. As a legal team, so we use the law in both contentious and non-contentious ways. So we inform the law. So we do a lot of work writing briefing papers or getting counsel opinions on key blockers or issues or responding to consultations. We also work on enforcing the law, so litigation or regulatory action. a recent piece of work I could tell you about. One of our kind of bigger projects that's been going on for a couple of years now has focused on liquefied natural gas, so LNG, and its promotion as a transition fuel, particularly by the fossil fuel industry. And we've tackled this problem from a couple of different angles using different types of law. So using consumer law, we've brought greenwashing claims against actually cruise ship companies. So cruise ship companies are advertising liquefied natural gas, LNG, as a clean fuel or a green fuel. And after a couple of years of work, the Advertising Standards Authority that Ricky mentioned in the UK have just this summer issued a series of rulings against cruise companies for that greenwashing. And the Dutch Consumer Advertising Authority also did the same earlier in the year. And then in the same project, we've approached from the kind of the finance side as well. So we're also currently engaged in a piece of litigation before the EU General Court, which is against the EU Commission in relation to their sustainable finance legislation in terms of its support for LNG as a transition fuel. So that's still ongoing, but that's a sort of example of how we try and address problems using different types of law and from different angles. Certainly, I think it's an exciting place to be, but I think these kind of transition questions are really interesting, and it's the kind of the next battleground, if you like, with the perpetuation of fossil fuels through the next version or claimed green version. I'll leave it there so we have time to go to the next question. Thank you.
Amazing. Thank you very much. Well, we just already heard of a wide variety of legal tools being used. And so the next question is, how does your organization's theory of change or kind of mission statement or vision inform the tools that you use or the tools that you choose? So I'm really interested in the kind of thought process that goes into choosing the legal strategies, if that makes sense. And then for Ricky, in your litigation practice, focusing on climate litigation, what legal tools do you apply to advise your clients, essentially? So should we go in the same order? Is that okay?
Yeah. Do I need to lean closer to this microphone? Is that even changing anything? Really good on that. Okay, shall I just project? Great. Theory and the kind of theory and process of impact. I love this topic. I previously didn't, but you know, there's a whole. It was new to me when I first started in the third sector. I came to Client Earth from where I was previously to this role. I came to Client Earth from a corporate law firm, and I think one of the major changes, the biggest change of coming from private legal practice to an impact-driven organization, is the way that you think about the law and the concept of thinking about impact. So when you're in a law firm, you have a client that comes along, tells you their problem, you open the file, you solve their problem for them, you close the file, and that's it. It's quite a straightforward process. It's not straightforward. There'll be obviously, you know, the complexity of the legal question, but the facts come to you. Whereas in the third sector and in impact-driven organizations that use the law strategically, you have to go to the facts. The facts don't always necessarily come to you. And so you need to think almost backwards, and you need to flip your way of thinking from receiving information and working through a problem to thinking creatively with the law. And that's a fundamental shift for many lawyers, I think, who aren't typically used to thinking creatively, dare I say. And so there are whole theories and you know, academic works and texts on the concept of change and how social change happens. And so there's a whole kind of literature out there around how social change is created in the world and how the law affects that. And that's all fascinating and was new to me. And, you know, there are many different kind of modalities and many different methodologies for creating a theory of change. Sometimes it's called critical path thinking or systems change or systems thinking. That's pretty big right now. But basically you're going right to left. So you're starting at what do you want to see happen in the world? Like, for example, reduction in the UK's greenhouse gas emissions. And what are the building blocks and the preconditions that need to occur for you to get there? You need to think about what assumptions underpin each of those steps, and you need to test your assumptions. And then, you know, you can build something called a theory of change or a critical path. And I would say, honestly, in this work, 50% of the time is taken up thinking about impact and how whether what we're doing is going to make a real change in the world. The legal side is not important. Obviously, it's really important, but the thinking around non-legal factors like how does this legal strategy interact with the political environment? How does this legal strategy interact with the finances of this company or this project or whatever? How does this legal strategy interact with social, political campaign and policy? All of those factors are just as important as your legal knowledge. Because as I mentioned, you can have a really great legal result and the UN special rapporteurs can say, this approach is illegal under international human rights law. You know, well, great, good for us. But what actually changed? Did that change Shell's behaviour? I don't think they care a jot. Did that change the behaviour of the UK government department that manages the UN guiding principles, which is FCDO? No, I don't think they care either. What is going to make an impact on those entities that we're trying to change? So it's a totally different way of thinking.
Very interesting. Thank you. Ricky?
Yeah, I think I can follow on quite nicely from that and talk about, you know, obviously as a law firm, we don't have a theory of change because we are just looking at that one tool in the toolbox. And I think the most important thing for us is to realize that we have to be part of something much bigger and part of a much bigger campaign, and have some humility about how much the law can achieve and how much in particular litigation can achieve, because we are basically only contentious lawyers, and litigation is one of the many things that our clients can use to achieve the change that they want to see. I think in terms of the work that our team does in bringing judicial reviews, what's useful about a judicial review is it brings accountability in a way that the strategies find it harder to achieve. So, you know, there might be a campaign on an issue, and the NGO might have been trying to get answers from the government for years about, you know, what they're doing on a particular issue. You know, we brought a case on food waste reductions, and the government department who was responsible for that were slow pedaling on commitment they had made, and as soon get answers in a way that you wouldn't otherwise get answers, and then by actually bringing a judicial review, you may not, you know, the opposite to what Sophie said might happen. You may not get a good legal result in that you might lose your judicial review, but the process will have elicited information which might be very useful, and it might also have elicited actual change in what the government's policy is. So in responding to judicial review, the government has to set out its stall, and sometimes in setting out its stall, it clarifies things in a useful way. We brought a judicial review against the Environment Agency on behalf of an NGO called River Action, which was about the Environment Agency's policy on enforcing regulations which governed the spreading of manure on agricultural land. And in responding to the judicial review, the Environment Agency actually changed the wording of their policy in a useful way. The judge also set out a helpful clarification on how the regulations were meant to be interpreted. That was the opposite of what the government said that the interpretation was. So it was a useful judicial review, but we actually lost at the end of the day, because the Environment Agency could say that they were still acting within the lawful limits of what their discretion was in terms of enforcing the regulations. But it was a very useful case to bring, and it also drew attention to an issue. So it drew attention to a campaign in a way that other strategies might have struggled to do. So these cases they can be very useful in some ways, but ultimately they are just one part of something which is much bigger, and we as lawyers need to keep an eye on that.
Thank you very much. Memo, do you want to go next?
Yeah. I think for us, as I said before, the main or the most important thing of our theory of change is using the contracts and legal processes of the day-to-day of companies to actually hardwire sustainability there, right? And bring people to actually reach their goals, what they're saying in these glossy PDF reports, to actually something meaningful and real. So I think that's the most important part of our theory of change. It's because it's accessible to everybody. Everybody uses contracts in their day-to-days. But I think the other important part is the other side of the street, which is the lawyers that help draft those documents and the mindset that comes before writing a document like that. So we're trying to change those mentalities and to actually bring tools for people to use in their day-to-day. We created a systems mapping of the cycle or the life journey of a solicitor in England and Wales to see where can we actually act to give what people need, right? We know some partners in the law firms want to embed this, but they don't feel comfortable enough talking about climate risk with clients, so they will never open their mouths about it without properly knowing. So we're trying to solve that issue, but also from the students, right? There's also this culture of the SQE and the trainees that have to go through certain careers that you might forget in 2 years your sustainability desires, right, when you were a student. So we're trying to actually change a little bit of that while focusing on creating content for their contracts, which is very important because we try to shape how they are behaving and how they can help their clients. I always say it's a very cool side of the story because we can show that you don't have to be an activist to actually have an impact on these kind of things, right? But sometimes people hear about climate change, specifically in law firms or in the legal perspective, and they think in litigation and they think in activism. So we're trying to rewire that story to you can be a corporate lawyer working in your M&A deals and actually embed a lot of sustainability into that business and into that client. So I think that's what we're trying to do, which is a little bit difficult because it's very difficult to change that mindset of the billing hours and just searching for the profit while not thinking that climate risk can actually be a huge loss of profit to your client in 5 or 10 years, right? It's not like 30 years ahead of now, how we thought before. Now you can tell your client you can lose thousands of dollars in a year or two. So I think it's just rewiring that mindset and that communication we have with the clients, and we're trying to help lawyers do that.
Amazing, thank you very much. David?
Yeah, thanks very much. And I think, Sophie's comment about the different approach to the law and using legal approaches in an NGO compared to private practice really resonated with me. And our theory of change focuses on using the law very strategically to try and maximize the impact of our work. So I like to think of it as kind of what's the smallest legal lever we can pull that has the biggest impact. And we spend a lot of time at the beginning of each project working on the strategy. And within that strategy, the legal argument is only one part of that, and often the part we can be most confident about. The other parts of it are, where is the rest of the impact? How is that going to be received by investors? What are the conversations going to be in the corporate boardrooms about it? What's the public opinion? Is there a risk of backlash? What do policymakers think of it? So I just echo the comments of the other panelists that it's all these different factors that come together that you have to think about in terms of what kind of change are we going to see at the end of this, and how we're going to communicate about that. And I think that's the other thing I've really learned since working in NGOs, the importance of the communications team in your NGO to good legal strategy.
The perfect roundup. Thank you so much. Well, the next question really was to elaborate on the kind of difficulties and limitations that you run into in your work, particularly in applying the law for change. I know that all of the speakers have very helpfully touched on this already, but if you would like to elaborate, no worries if not, on the extent to which the law is then a useful tool for meaningful change. I mean, we're all lawyers here. Hopefully not all is lost for the profession in terms of making a change. So yeah, if you could please elaborate on that.
Yeah.
I think you can quite quickly get a bit philosophical about this question, because for me, I sort of go back to, well, what is the law? Law is just our social construct, and it's our social relationships, and it's this kind of basic norms, these basic norms in our society. You know, I'm a lawyer, so this is the tool I have, and we're all lawyers. This is my particular skill set that I can give to create change. It doesn't necessarily mean, as Ricky said, that the legal strategy is going to be the only tool in the toolbox for a well thought through and coordinated campaign on any particular topic. But it's one tool in the toolbox, and I'd say it's pretty important. It can cut through sometimes. It can cut through political controversies and challenges, and that's a real benefit of the law. Subject to, of course, you know, democratic norms and legal principles being enforced in a healthy, functioning society with, you know, neutral judges that aren't politicized. So we're seeing the erosion of all of those principles that we all hold dear, and it's terrifying, frankly, but that I digress. I think one of the most important challenges, and throughout all of this work, I've always really noticed that, of course, context is everything. So, you know, cases in some countries that, you know, seem quite reasonable and justified, climate change cases, will never work in other jurisdictions. And so legal context and legal culture and the socio-legal norms that exist there among the judiciary and among the profession are so crucial to understand in planning your strategy. That's absolutely everything. Then, of course, one of the major challenges with the law everywhere, in this country as well as in Pakistan, is enforcement, you know, and compliance. A story that we often told at Client Earth when we won the Clean Air case for the first time, there was no binding remedy on DEFRA at the time to comply with the European Air Quality Directive. So the court had said, yes, you're out of compliance, you exceed the parts per million level, and it was a very concrete limit. And DEFRA didn't have any funding to comply with that from Treasury. And so then I think we went back 3 times to get a stronger remedy, and we actually got an enforceable injunction against the UK government for the first time. But the point being that even in a country that very much respects the rule of law, enforcement is still always a challenge. And we're seeing that in Klima Signorina now. And then in some countries, you know, Pakistan was one of the first cases to have the Ligari case, and they had an absolutely brilliant judgment. But has that affected the greenhouse gas emission trajectory of Pakistan? I'm not quite sure. So everything depends on the context, everything depends on enforcement, everything actually depends on the follow-up. You can't sort of stop at the end of the case either. You need to keep pushing, even if you have a win.
Great, thank you very much. There is some hope in there. So
Yeah.
thank you. Ricky?
Yeah, similarly, you know, I worry about the continuing applicability of the rule of law elsewhere, also in the UK. It's worrying. You know, I could also bring up enforceability stories or horror stories, but on a different note, I think one of the issues that we face, particularly in the UK, and particularly in the judicial review context, is that that judges are inherently conservative in a small seat way. When we are challenging decisions of the executive, and judges are inclined to buy into the public body decision makers' view of things or their defense. So you know, it's very difficult for us to win a judicial review in that we get the remedy that we asked for from a judge, and that can be very frustrating for clients. And I think the difficulty we face is you know, explaining to them and also justifying to ourselves that cases are still worthwhile to bring, even if you may not, you know, the chances of getting the remedy that you want are low. It's very, very rare to go into a judicial review thinking that you have a better than 50% chance of winning, and that's a challenge for a public lawyer, a claimant public lawyer.
Absolutely, thank you very much.
Yeah, I think from our perspective, from the non-contentious side, obviously law is indispensable, but I think it's not enough on its own. Like, we know litigation, regulation and policy are the ones setting the rules of the game, but with your contracts and your daily processes, you're also shaping that game every day, right? So as Sophie was saying, I love to bring creativity, because that's also where lawyers can be very, very creative in creating and drafting these documents. So I think one of the ways that we act in a faster way, we don't have to wait for regulation or for some law to tell us to do it now. We can do it through the own documents that we draft every day. So in a way, we see it as a everyday tool that you can use to get impact quite easily. But I mean, of course, there's many blockers, but it's where creativity and the lawyers drafting can get their heads in the game.
That's excellent, because we'll be having a creative discussion later on. So please do stay for that. Thank you very much.
Yeah.
David?
Thanks very much. Yeah, I would agree with the other panelists.
Cut out a bit. Sorry, David, I think maybe your headphones have cut out. We can't hear you.
I can hear you.
Perfect. Yeah, it's
Yes.
great now.
Yeah. Okay. Sorry about that. Yeah, I was just saying I agree with the other panelists that law is kind of one tool in the box. I think the panel has a good mix of that kind of the two different approaches, the kind of non-contentious and contentious, and I think that's the sort of key way that law can be used for meaningful change. So there's ultimately, like, in theory, and I take Sophie and Ricky's comments on board, but in theory, law sets the boundaries of behavior in society, whether that's individuals, governments, or corporates in their contracts. So we've got the opportunity to use it, A, to set the boundaries of those behavior consistent with planetary boundaries, and then B, to enforce those laws. And I think on both counts, we don't have enough lawyers doing either of those things, but we could definitely do with more, certainly at NGOs on the kind of enforcement and compliance side.
Thank you very much, David. We will now talk about collaboration, cooperation, which again, many of the panelists have already touched upon, but it would be helpful to kind of zoom in on how you work with other lawyers. So conscious that, there are loads of different kinds of lawyers. There are obviously solicitors, barristers, academics, other NGO lawyers, and so on and so forth. And so it would be interesting, because the way I envision kind of the climate legal space is that it's an ecosystem of different people who do different things, and yet we all come together to achieve kind of legal change. So it would be interesting to hear your views on that.
Yeah, it is an ecosystem with, many non-linear connections amongst people. I mean, we work with absolutely everyone on that list in all sorts of different ways. I think in my experience, in my professional experience, no project is the same in terms of the way that it's structured and the way that we collaborate with other groups. They're all slightly different depending on what we're trying to achieve, the project, and the specificities of the project. I mean, that's such a lawyer's answer, but it is case by case around how we collaborate. But yeah, working all the time with academics, working all the time with Leitane, other actors within the ecosystem. Those that are philanthropically funded, often that, the funders actively put people together and seek to ensure that they do collaborate. So there are many schemes for coordinated and structured collaboration as well.
Thank you.
Well, we because we work with a lot of NGOs, and as you can see, there's lots of lawyers working for NGOs. Often we are working with other lawyers, and the people instructing us are other lawyers. So that's brilliant in that we get people who really know their stuff, and they'll almost certainly know the issue that they're instructing us on in much more detail than we do, because they would have been thinking about the issue in a much broader context than just the litigation context that we get involved in. What's interesting is when we work with lots of NGOs and NGOs working on similar issues, and they are often collaborating well together. Sometimes it becomes trickier when we're instructed by an NGO on one issue, but we might know people at other NGOs working on the same thing, and they might see things slightly different from our clients. And obviously we have to be careful that we're acting in the best interest of our clients and keeping our clients' information confidential. And there is sometimes a balancing act in terms of, we're very interested in the issue and want to speak to lots of people about it, but then also being aware that we need to protect the client's position. That hasn't led to any major issues. It doesn't normally lead to any major issues, but it's something that you have to keep your eyes open to.
Thank you very much.
I think for us, collaboration is core, because as I said, we were born out of a hackathon. So it was basically lawyers creating the content for us. So I think in our day-to-day, it would be definitely solicitors and law firms, the one that we talk to the most. But recently, and as we are maturing and trying to test our case studies and our impact, we're talking more to the regulation bodies, right? The Law Society, for example, it's a huge player here, and we want to actually help them understand more risks and understand what practices are best to start doing something, right? For example. So I think the professional bodies and regulators are important as well. And the academia, because sometimes we try to also push this mindset to the classrooms, which sometimes it's super difficult, but we're helping them to push this content into that. So yeah, I think cross-pollination is essential, because we also talk to non-lawyers, specifically in supply chains, which is a great area to start your decarbonization journey as a company. So we also try to make our documents, which are catered for lawyers, to be also user-friendly for a non-lawyer, that it might work with contracts in their day-to-day. So it's a little bit of everyone, honestly. And I think that set of collaboration, it's also the community building that LVF is so good at, that we're trying to enhance for other organizations as well. So yeah, I think it's a general collaboration.
Amazing, thank you. I appreciate the shout out to the regulators in particular. That's always
Yeah.
nice to commemorate them. Thank you. David?
Yes, I agree. It's a very collaborative space. I think, relatively speaking, there aren't very many legal NGOs, so it's good that we all work together and we test ideas and we share experiences and share expertise. But we also work closely with solicitors in private practice and barristers, mostly in the UK, but we're in fairly constant contact on our project and get a lot of support from them. And I think that really helps increase both the amount we can do as an organization and also the robustness of our work. So yeah, it's a very collaborative area, and I think also on the academic side, we do lean a lot on technical and scientific experts, and they really sort of make our legal arguments work and make sure that we're arguing for the right thing. So that's vitally important as well.
Thank you very much, David. I think it would be good to mention the Grantham Research Institute here as well. Shout out and thank you for hosting us. They offer incredible tools that I know that we at Opportunity Green, and I'm sure many others, use on a daily basis almost in our work, including the kind of annual strategic litigation snapshot and the database of climate litigation cases that they have together with the Sabin Center. Recognize it's very litigation heavy, and apologies for that, but it is what it is. Thank you. Moving on to the final question for those of us in the room who are considering our careers and the progression of our careers. How did you end up working where you are, and what advice would you give to someone who wants to build a similar career? Sophie, would you like to start?
So I started to work, I got a job at Klein Earth in 2015, and I do think this is a good story because I read the job description and I thought, I will never get that position. I don't have all of the relevant bullet points in the JD. And I said to my ex at the time, I'm so sad, this is my dream job, but I'll never get it. And he said, oh, why don't you just write to them and go and volunteer for a few months for free, like say that you'll work for them for free. And so I wrote to my old boss and said, hello, here's my CV, I'll do anything. And she said, don't do that. We don't accept unsolicited internships, but you should apply for this role, a role that I thought that I would never get and that I was unqualified for. I did get the role. I was totally qualified for it. And it just really made me realize that don't underestimate yourself ever. And always apply for a role, even if you're missing one bullet point. It doesn't matter. Most people are missing several bullet points. So if you get if you get all except one, then you're doing really well. And just if you really have a passion for it, just continue until you succeed. I mean, in hiring at Klein Earth, I hired a lot of people, and there were quite a few that didn't get hired the first time, but then people just continued and kept on going, and eventually they found a position. So yeah.
I think that's a really important point, and I had the same experience at Opportunity Green. Frankly, I didn't think I was going to get it, but I was like, I have nothing to do on a Wednesday afternoon. Let me just apply for the job, and here I am. So definitely, thank you. What about you, Ricky?
Yeah, it's hard to come up with concrete advice. You know, I really agree that you should always apply for jobs you want, no matter what. And doing applications makes you better at doing applications. I started out as a commercial planning lawyer, and sort of that led me into doing environmental judicial review and eventually to this role. But you know, it's not something that I started out my career thinking I would do. I think if I'd known about this sort of job, I would have wanted to do it, but I didn't know this sort of job existed. And so I would say your career will involve many steps, and it will change a lot. That will happen. That will happen to all of us. There are very few people now who start off doing one thing and then do that for the rest of their lives. You know, do that kind of law for the rest of their lives. And I think being open to different possibilities of what's out there. You know, you might all want to be climate lawyers or whatever, but those are maybe loads of other types of law or other things that that you don't know about at the moment, and your path to get there will be circuitous. So you know, that's getting quite philosophical, but I think like you know, what I see a lot in junior lawyers at Leitane is they have such a fixed idea of what they want to do and how they get there. And actually, most of the people who are more senior didn't start out as paralegals at Leitane and then stay there forever. Some did, but most of them didn't. And I think being open to other types of job that you might not have in your head at the moment is a good idea.
Thank you very much. Again, it's very valuable. And I think Gen Z is kind of famous for job hopping anyway. So hopefully people will take your advice on board. Guillermo?
Yeah, I think I'm a Gen Z at heart because not been very linear. I started working back home in a big American law firm for some years, which I think it's where I built up my legal skills. So one of the advice that I always give, I was doing my own legal tech back home in anti-corruption. So to be able to fund a startup and actually understand client needs and pain points, I needed to have that experience before, right? So I know it's painful to build up these years of skills, but honestly, in my case at least, I wouldn't even like dreamt about the problems that I was solving with the startup if I didn't know the clients and what were they working in their day-to-day. So I think a piece of advice is that just build up a little bit of legal skills before trying to move to one of these ecosystems, right? I was doing before sustainability, anti-corruption, and I can actually draw a lot of links where they are very similar, especially to clients and how they address it. So that's a good thing to understand. And as well, like Sophie, it was very funny how I got my job in TCLP because I came to the UK to do an MSc in law and finance. So I wanted to stay more into the finance and legal tech thing. They were posting a job of a senior associate in FinCap. So I was like, it's perfect for me. I did really well in the process, but then I got a call from our CEO and he told me like, you know, we don't want you to give the FinCap role to you, but we understood that you like entrepreneurial stuff and you like to think outside of the box and not to be the traditional lawyer. And they offered me a position like entrepreneur in residence, which I honestly love. And when I see backwards and see if I have gotten the FinCap role, I would be very, very sad. So sometimes you just have to trust and know that later on connecting the dots, it all makes sense. So yeah.
Yeah, trust the process. That's
Exactly.
really important. Thank you. And yeah, David?
Thank you. Yeah, I'm a little sad that I'm now old enough to be asked for career advice. But I guess at the outset I would say, you know, this wasn't my plan, and I didn't really have a plan 10 or 15 years ago, if I'm completely honest. And I'm really impressed by law students and the young members of the profession today that are asking these questions and thinking about these things. I think it's a lot easier to join the dots looking backwards than it is looking forwards. So as I say, my background, I was a commercial and corporate lawyer in the UK and in Aotearoa, New Zealand for several years, and then decided I wanted to shift out of private practice, and I did an LLM in climate change law at Edinburgh. I was actually led to the opportunity green job purely by chance from a text from someone I was doing a climate change leadership course in Scotland with at the time. So sometimes it's really very little things that can have a big outcome on your career, and it's hard to always know what they're going to be. But in terms of advice, I'm probably sort of echoing things that have been said by the rest of the panel now, but I think it's really critical not to discount yourself. And I was in Sophie's shoes as well, looking at people in the profession like Sophie, thinking, you know, there's no way I've got the skills to be able to do this. But most of our legal team at Opportunity Green have done something else first, and I think we can sometimes think of climate law as a specialism, but it isn't really a narrow discipline. In fact, it's the exact opposite of that. It kind of touches on everything. So it's all about the transferable skills I think you can bring to that. So we work across the breadth of law, corporate law, consumer law, tort law, everything in between. So definitely don't discount yourself from a job because you don't think you're a climate lawyer. And then the second piece of advice would just I've been really interested listening to Guillermo today. You don't need to be an NGO if you want to be a climate change lawyer. And I think that message that all lawyers should be thinking about how they incorporate climate change into their everyday practice is a really important one to take away. And I think it's really important that lawyers of all stripes practice climate change as part of their practice.
Brilliant point, actually, to end on, that all experience is valuable and people everywhere through their work can make a difference. So thank you very much, David. That rounds us up really nicely to take some questions from the audience, if that's okay with everyone. Shall we start with people online? Okay, let's see. Do I have time to take all of these questions? Okay, so people have spoken democratically. To what extent do resource constraints influence your litigation strategy? Or perhaps to open this up to Guillermo as well, your legal strategies. Does anyone want to go first with that? So resource constraint.
I can go if you want. I mean, I think resource constraints means funding.
Sure.
It's a key. I mean, it's a huge issue. It is one of the main considerations for clients as to whether they'll bring a claim. You know, but both for the public law work I do, where there's no way for us generally to recover our costs from the other side in any meaningful way. So clients do need to fundraise to cover something towards our costs, but also in the private law work, where cases are often funded by commercial funders, and that means that only certain types of cases are taken forward. And you know, for us, the crowdfunding has been a complete game changer, and really is the only way that we will be able to do the work that we do, and didn't really exist in any meaningful way, you know, 8 or 10 years ago. But it does mean that the cases that we bring are the ones that people can crowdfund for. So cases about badgers or red squirrels are much easier to bring than cases about, well, particularly cases about, you know, some very important but quite technical policy issues. It's difficult to get people interested, and we can do some cases on a complete pro bono or conditional fee agreement basis, but it's just not possible for us to do that for the majority of cases. So yeah, it's a big issue.
Thank you very much. Does anyone else have anything to add, or shall we move on? There's another question online, which is quite interesting. So it pivoted onto the recent ICJ advisory opinion. And then it asked, to what extent are non-binding rulings relevant? But I think it's also particularly interesting because we talked about various soft law mechanisms, such as the UN special procedures and greenwashing cases with the regulators. So to what extent are non-binding rulings relevant? Does anyone want to take that?
I will, because I wrote a journal article on this earlier. Yeah, that was published earlier this year. And yes, it really does matter, because in national courts in many jurisdictions, international law is directly incorporated into domestic law. And so the ways in which the ICJ's advisory opinion will infuse and be used in domestic litigation are multifarious and could really permeate even in jurisdictions where, say, they don't directly incorporate environmental law. Sometimes legislation brings in principles based on the international human rights treaties. And so what the ICJ has said about those treaties is therefore potentially relevant through incorporation in domestic legislation. So that's just to begin, but then there are, the many other ways that these concepts, definitions, influence the judiciary, around the world globally. We've seen that in the growth of climate change litigation in the last 10 years. That's been a kind of revolution in legal thinking and jurisprudence, and the ICJ is just sort of continuing in that way. So it doesn't change the world overnight. We didn't wake up the next day and suddenly, everyone was on a 1.5 degree trajectory. But it's still, I think you can't underestimate how important it is and the ways in which it will affect decision making. That's my personal view.
Thank you very much. Very hopeful. Does anyone want to come in on the ICJ or any other non-binding rulings or decisions?
But I'll just say very briefly, in the greenwashing context, an ASA ruling against a company is the ASA doesn't have any powers to get anyone to do anything, but it's hugely damaging, and advertisers are very very keen to avoid a negative ruling against them. So it is still powerful, if only a soft law remedy.
Thank you. David, did I see you try to unmute yourself?
Yeah, I was going to make a similar point to Ricky, actually, but yeah, just on the soft law mechanisms, and I think it's related to the first question, really, is the maybe the funding issues around kind of your big ticket litigation. One of the questions I think it's important to ask ourselves is there a way to achieve this impact? Is there a way to achieve this change through different means that's kind of cheaper? So you could have your kind of private law claim with the time, expense, and funding that brings, but is there a soft law mechanism that actually gets you to the same point quicker and potentially much less cost?
Thank you very much. I would actually like to add to that, especially when it comes to the ICJ, that really hammers home the importance of communications. I know that many NGOs, again, have communications teams within themselves, or they collaborate with other people who are comms specialists. And I think it really is, there's so much in the narrative and how you frame a particular outcome. So for example, with the ICJ, you could talk about how it's the first unanimous advisory opinion in almost 40 years, I believe, and that really adds some strength to it. So it does matter how we as lawyers communicate and talk about these things, just as a little minor point. Shall we take some questions from the physical audience? Yes, we have Ainsley, please.
Hi everyone, thanks very much for your talk and panel discussion. It was amazing. My name is Ming Zi. I'm an associate at A&O Sherman's Environmental Law department, and I also co-founded Legal Voices for the Future. So I have two questions. The first one kind of builds off Dominika's point around what do you see as the role of media and what is your media strategy? I thought it was really interesting, Sophie, what you said about the international press's like appetite for climate news nowadays. So yeah, just a bit on what your media comm strategy is. And the second point is around legal ecosystems and where you see there are gaps in what climate law NGOs aren't addressing at this point. Thank you.
Thank you. Would anyone particularly like to handle those?
I can talk to media. I think that's the easier question. Media is hugely important for our clients, and we have a very good press office. And because the cases we bring are part of larger campaigns, by bringing a legal challenge. Well, one of the purposes of bringing a legal challenge is to get media attention on the issue. So it's hugely important to if we have any sort of win or news, we try get a press release out. We might work with journalists to get an exclusive, and sometimes we get coverage and sometimes we don't. But yeah, it's very important, and it's something that we are thinking about, that the lawyers have to be thinking about as well.
Very much. Does anyone want to come in?
From the question about what's lacking in the ecosystem or where we see gaps, it's actually in the, I think, awareness and training for lawyers on these issues. Some difficulties, it's because of there's no funding and there's no appetite of funders to fund programs like that. So I think that's a huge problem that can be maybe addressed using law firms' money or more private money and do some collaboration like that. But I think definitely awareness and training for lawyers on these specific things.
So again, is that importance of collaboration and
yeah,
cross?
And also lack of funding, I think.
Yes, that's a very good point. We have time for one more question. I believe, Matilda, you were first. Sorry, Marina.
Sorry. Oh. Hello. My question is kind of related to some of the things you've touched on, and you spoke of funder appetite there, Guillermo, and I wondered the relationship between impact and funders and how monitoring and evaluation, for example, using the obtuse example of Client Earth and Shell, so much of that of what was gained there was like pushing litigation risk up the agenda, but you can't measure that. So how does the relationship between what you want to achieve and what you have to prove to get funding work? And maybe modifying that for Ricky a bit, how impact relates to your business model and whether you kind of would ever not take a claim because of whether it aligns with sort of Leaday's general business model or work.
Can I just add that my question was exactly have there been any times that because of funding pressure or lack of funding, you've had to tone down projects or continue the project in the knowledge that you're not going to have certain funding backup, and what drives that?
Interesting. I see the question.
I can take at least the first one because that relates to a project that I was involved in. Yeah, impact measurement is notoriously difficult, especially for legal work and litigation work, because it's indirectly related because of the enforcement challenge, I think, actually, and the indirect effect that achieving, say, declaratory relief or proving some other legal principle that isn't, shutting down a coal-fired power station with 25 gigawatts, of electricity and therefore greenhouse gas emissions. So it's very challenging to talk to funders about legal and litigation impact, but again, there's more literature out there. There are more people that are studying this. Actually, after the Shell case, happily a PhD student who was studying impact from climate change litigation is doing they're doing their PhD on impact from the Shell case, and so interviewing lots of people. She's got a special methodology and is doing like a sociological kind of study. So yeah, I guess you have to rely on qualitative interviews and feedback from the field. So there are a lot of surveys that are done. But yeah, it's hard, but it's not impossible. Some funders get it. Some funders are on a journey, and you just have to go on that journey with them.
I think the question was, would we turn down a case? Yeah, I mean, we turn down cases that we don't think are that don't align with our ethos. So we turn down judicial reviews that challenge renewable energy projects, even if they've got good grants, and we turn down campaign groups who are opposing low traffic neighbourhoods. We have to be careful because we also can't we don't want to inadvertently discriminate in turning down a case, and that is a feature of other parts of the firm. But we can generally turn down cases for those reasons. Often we're very busy, and so we might turn down cases that we think are less important, but we would be more likely to take on a case even though we're busy if we think it's an important case. So that does weigh into the decision making. Equally, sometimes we would take on a case that pays better, even though we don't think it's an important case. So we need to be self-sustaining as a practice, and so there are cases that we would prefer not to take on, just because they're not the most interesting cases. But if the clients can pay, then we would take it on.
Thank you very much. Anyone else?
Yeah, I think for us, it's always difficult. I think the relationship with the funders, I think you know that as well. But yeah, I mean, for us, it meant that we were speaking at the beginning of TCLP of a true and very quantifiable relationship between the use of contracts and tons of carbon out of the ecosystem, right? So it's a very difficult link to draw. It's a very difficult data to gather from lawyers because the attorney-client privilege, we would never know what's in the contracts, what was the money, what was the carbon that was not set out. So it was very difficult for us. So we pivoted into more case studies and show impact through how people use our content. But sometimes we're just used to see numbers, right? So it's very difficult for many funders to understand impact, that it's not quantifiable in profit, in money, or in tons of carbon. So I think it's also very similar to startups, where you have to decide which VC funds, or in this case, which funders to be linked to. Because we have always also had some good experiences telling us, you're the first legal NGO that we're funding, because we would never fund litigation. No? So I think the sun shines for everybody, and you just have to decide which are the best to work with. And especially now also, it's very easy to decide on projects because you could have a really good return on your investment, so to say. For example, in AI, now that everybody wants to talk about, I think if you already have some knowledge on that and you can work on how to embed sustainability into AI, for example, that would be great. And there would be a lot of appetite from the funders to do so. And then you can have your hidden agenda and put some of the stuff that you really want to do in those projects. So I guess it's case by case, as Sophie says.
Hidden agenda. David, do you have anything to add, or are you happy to move on?
Yeah, I would just echo the remarks about the difficulty of measuring impact. I think, intuitively as a contract lawyer by background, I know that legal risk is an effective tool in changing behavior, but it's very difficult to measure that change of behavior. But I think you rely sometimes on some signals. So to give you a concrete example, when we launched our case against the EU Commission, it was picked up in quite a niche is relating to aviation and shipping, but it was picked up in quite a niche aviation investor publication. And the publication was remarking on the risks to investments in the aviation industry in the EU while this case was ongoing. So you start to see that there are kind of impacts, but you might never know exactly what those are. And I think that goes back to kind of the earlier point about the value of communications and effective communications, especially in cases, because often the outcome can be several years away. So it's really important what the kind of interim communications say about that case.
Amazing. Thank you very much. I think that's all we have time for today for our panel. So let us say a huge thank you again